So friends, while we understand that the rule on judging capacity of parties is based on mental capacity, hence minors are excluded from contractual right to make agreement. But when you look at the Indian Contract Act 1872, there is a section called Section 68. Now, this section, friends, is a section that looks at what we call as obligations that are externally imposed, right? What does that mean? It means that the Indian Contract Act says that there are certain relations that resemble a contract, and this is what we call as quasi-contracts. The term quasi means semi, right? It's not a contract, it's not a full-fledged contract, but it is a semi-contract. It looks to be like a contract. Relations that resemble a contract. And that is the title to the chapter before Section 68. We have quasi-contracts from Section 68 to Section 72. And please note, the law says that irrespective whether the contract is made or not, these are obligations that will be imposed under contract. So they're not necessarily obligations that are agreed between the parties, but because the relationships are such that they look to be contract, the obligations will be imposed under contract law. So contract law 1872, friends, clearly stipulates the kind of obligations that parties can undertake on their own instance, on their own self, right? Self-imposed obligations. So they can make an agreement of their own choice. But in certain cases, even if that is not present, if the agreement is not present, if the other party is not present, as I told you earlier, the law of contract is based on the law of obligation. These obligations will be imposed. And one of the sections that deal with incapacitated persons is Section 68. And incapacitated persons mean those who do not have capacity to contract, and that could include a minor or an unsound person. And hence Section 68 says something like this. It says that if a minor has been supplied with goods that are necessary for his life, right? This could be food, clothing, and shelter. These are necessaries of life. If someone supplies to a minor goods that are necessaries of life, then the minor is obligated to pay for the same. Yes, this is very clear. So, this is an exception to the minor's liability in contracts. While we say minor has no liability in contract, the contract is not going to be enforceable. This is the first exception, right? Which means that minors can be supplied goods that are necessary for its life. Obviously, you don't expect a minor to go hungry. Let's assume that the minor has no parents, he has no guardian to take care. He is a 16-year-old or 17-year-old actually studying away from his family. Now he will go to buy some necessities, right? They could be food, it could be grocery, it could be clothing, it could be medical emergency services. Now all of these, you will notice that you don't want society to stop supplying these to minors. And I think the drafter was very clear that even incapacitated persons have the right to be supplied with goods that are necessary for his own life. These are exceptions to the capacity to contract. So the minor does not have capacity, but anyone who supplies these goods to the minor, right, for his own livelihood purposes, the minor is expected to pay. The minor has an obligation to pay. Now that obligation is not a full-fledged contractual obligation, but it's still a legal obligation. It's based on the moral obligation that, look, if you have received goods from someone, you better pay for it. Whether you had the capacity to contract or not, that's a different issue, right? This is simply based on what we call as, the principle of unjust enrichment, and under the doctrine of restitution. Restore back the goods if, you think you cannot pay, but in case you want to keep the goods, you better pay for it. Right. So I think minors' liability for necessities of life, I think, is a very, very important exception to the minor, and I think to that extent, it very clearly states why obligations under quasi-contracts are imposed, and minors are definitely responsible for those kinds of obligations. Now, one will have to note that necessaries of life, friends, is quite subjective to the minor's lifestyle, his cultural background, and so on and so forth. So there is no one single test of what that necessaries of life could be. What is necessaries of life to a minor in UK need not be necessaries of life to a minor in India. Right? It is quite subjective. Right? So there have been cases where people have asked whether a marriage engagement ring can be considered necessaries of life. The minor was in a hurry to marry. During those days, this child marriage prohibition acts were not in place. A minor wanted a suit. Can that be considered necessaries of life? So I think, while we say what is necessaries is very, very subjective to the minor and his conditions of life, we can always say that these are certain basic things that a minor should be entitled to in a given society, to be supplied either by the state or by the non-state actors, by anyone who thinks, yes, the minor is entitled to. For example, a minor goes to a restaurant. He's a 16-year-old. He wants to eat. Now, do you expect the restaurant owner not to give him food? Please note, the minor may have capacity to pay. He has money, but the contract will not be valid because the minor does not have capacity to contract. Now, do you expect the restaurant owner to serve food or not to serve food? So, minors, you will notice, friends, have been engaging in a lot of necessities of life journeys, be it by aircraft, bus, or train. They could be doing necessities of life in terms of eating, buying groceries, basic clothing, so on and so forth. So, I think all of these must be considered as those kinds of exceptions in which minors can be entering into some kind of an obligation, not a full-fledged obligation, it's a quasi-obligation, and those obligations will definitely make the minor pay for it, right? So the society has been encouraged to support minors, the society has been encouraged to supply these necessaries to incapacitated persons, and the law assures that they shall be paid for it, right? However, please note, while we say that the adult supplies these goods to a minor, the adult has to judge whether the goods are necessary or not. Right? So if it does not fit the test of necessities of life, the adult will not be able to recover. Right? So that is the strict condition of law, and based on that, we should understand the capacity of a minor. So there is quasi-capacity, and the minor is expected to abide by those quasi-capacities. Now, interestingly, you will notice here that apart from medical advice, legal advice or a rent can be also necessary, because when we say the minor needs a shelter to stay, a rental agreement vis-a-vis minor may be considered as necessary. Legal advice may also be important and necessary to inherit property, to make a sale of the property, to have a guardian in place. All of these can be definitely considered as necessaries. Say a bicycle to go to college or school may also be considered necessary. So these are some things that the courts have already decided as necessaries, and these are okay to be supplied to a minor. However, is a loan unnecessary? Now, if you go with the Mohiri Bibi versus Dharmodas Ghosh case, I think loan is something that the courts have always said is not something that can come as necessaries of life, and it cannot be attributed as goods. So any loan to a minor will still be continued to be held as something that is not recoverable, right? So supply of goods of necessaries does not constitute loan, money, cash, right? So there I think money lenders have been very clearly said, you please don't entertain this and the necessaries. You are clearly not allowed to make a contract with a minor. Those will still be considered as void, right? So these are certain things that we have to understand. And I think that makes this discussion a very, very interesting one. Now, continuing further, friends, if you look at minors today, one of the things that you have to understand is that the law, as it held in the Mohiri Bibi case and in the early times, to absolutely protect the infant or the minor, as the case may be, has evolved over a period of time. So the law has to evolve, the law probably has to change from a very rigid, strict interpretation. Probably it has to dilute its interpretation at some point of time and create and craft exceptions. One of the first things that you have to note is that apart from what is said by the Indian Contract Act, right, there are other legislations that slowly started crafting exceptions. For example, the Trade Union Act of 1926. The Trade Union Act, friends, is a very important legislation that brought in the spirit of collective bargaining, if you understand. And I think you will notice that while labor law came into India, even during the British times, they were actually trying to protect the interest of workers and laborers as being exploited. We know during the Industrial Revolution, because there was so much of gap between demand and supply. Now, If you look at the Trade Union Act, friends, which is currently also the law as we speak, where you can be a member of a trade union, right? And of course, if you are a member of a trade union, you have to be a laborer, you have to be a worker. And the trade union actually furthers your interest vis-a-vis the industry, vis-a-vis the manager. The Trade Union Act even today continues to state that a minor can be a member of a trade union. Though membership of a trade union is not necessarily contractual, but it says to a certain extent that, look, you can be a worker, you can be a laborer. And of course, the current legislation will not allow a minor to work in a hazardous industry that is hazardous to the health of the minor. But in certain kinds of exceptional circumstances, a minor can be also employed because he has the right to livelihood, he has the right to employment. So the crafting of exceptions can be arrived from two things. Please note it down. One, we say certain statutes created that exception. They allowed minors to enter into contract. Statutes itself started permitting the same. For example, the negotiable instrument. Now, do you need to be a major to open a bank account? Or can you actually execute negotiable instruments, including, please note, like in the Khanpur versus Lakasin case and others, can a minor execute a promissory note? Now, in today's times, I don't think we use too much of promissory notes or bills of exchange, but they are necessary in terms of understanding the payment obligations in contract, right? So, promissory note was an important payment obligation, a document assuring such kind of payment. And there was no prohibition under the Negotiable Instrument Act as regards can a minor execute a promissory note, right? He can definitely execute a promissory note. Negotiable Instruments Law 1881 allowed that as well. So that is another statutory exception that we think we should also look into. Similarly, the Transfer of Property Act, which is also a British-made law, clearly also stated that can a minor receive a gift. Right now, it's an adult who is actually transferring either movable property or immovable property, but it is gifted to a minor. Can a minor receive gift? Again, the Transfer of Property Act 1882 allowed for a minor to receive gifts, which means there is some kind of contractual obligation that he receives. Though it's not a liability, but it is a beneficial obligation which the minor receives. And Transfer of Property Act did say that a minor can also receive immovable property. Now, then finally coming to partnership rights. This is a law which we will discuss in detail under our contracts, because partnership is a form of business, is a kind of modern contract, as we see in terms of limited liability partnership. But we are talking of the law of 1932, the original law on partnership called the 1932 Act. Now, if one reads section 30 of the Partnership Act of 1932, you will interestingly find that partners can be admitted in terms of a minor can be admitted into a partnership, right? So you don't have to be above 18 to enter into a partnership. You can be admitted to a partnership, you can be a partner, but the only condition section 30 says is that he should be admitted only for the benefits of the partnership, which means till he is above the age of 18, he should not have liability of a full-fledged partner. Right? But he can become a partner. He can take benefits from the partnership. He can contribute to the partnership firm as well. So, which means a minor can commence business. He can commence employment. He can commence a enterprise. Right? So that is something that 1932 law itself provides. So that is a statutory exception that we see. Right? So from the strict rule, I think exceptions started crafting out with different statutes. Minors were permitted to do some of these economic activity, thereby contributing to social activity as well. And I think that becomes very, very clear in terms of what was the direction of law and what were the exceptions to the minority rule. Having said this, friends, you will also notice that other kinds of exceptions started crafting out. This we may bring it under the concept of what we call as judicial exceptions. So the judges and the judiciary started saying, look, there are certain contracts which may be purely for the benefit of the minor, right? Purely for the, it could be, say, service contracts. What are these kinds of service contracts? Let us say it is a sports contract in which a minor is being employed in a club. It could be a football club, it could be a cricket club, it could be a badminton club, it could be any other club, right? Now, this is not necessarily kind of labor or industrial relation, but these are service contracts where a minor actually is a kind of a rising sports person. He has a lot of potential. You see that that minors are actually, there are a lot of these talent identification companies. So they spot this talent quite early on, they give him the right training, it's in the right environment, and that's where they actually win a lot of championships, medals for their own country. So Olympians, Asian Games medalists are all identified when they're pretty young, and they're groomed, they're actually taken into a lot of these management companies. Now, all of these, friends, are purely for the benefit of the minor. We don't say the minor should have any kind of liability, though you can talk about quasi-liability of the minor, because such contracts may have the guardian also countersign the contract, right, in the modern context. But even if the guardian does not countersign, friends, you have to note that these are economic activity, social activity that are benefiting the minor's potential to achieve something for the society, for the nation, and for himself. And in those circumstances, these may be attributed as beneficial contracts. Now, please note, in common law, as well as in India, any contract that gives any kind of benefit to a minor is probably enforceable at law. They are fine, they are okay, right? And minors can sue. It's not allowing the adult to sue, but minors can sue. For example, look, I am a minor who has been signed by a club, and the club does not pay me later. Shouldn't I be able to approach to the court and enforce the contract in which the club had promised to pay me something? I think those kinds of rights of a minor to approach to the court and enforce a beneficial contract of the minor, I think the courts have always permitted that to do. So this then, opens up a big judicial exception to the minor's right to enter into a contract. So that is how it's quite an interesting dimension to contract law as we see. Now, with that discussion on minors, I think we clearly know that there was a rigid rule. From rules, we started creating exceptions. Now, those exceptions definitely allow minors to enter into a lot of these contracts. Most of these are under the beneficial rule. It could be, say, a child artist, right, who actually plays on television or on the movie set. Naturally, the child artist has to be paid, and there should be a contract regarding that as well. So many of these examples and instances can be brought about, and I think most jurisprudence supports the minors' beneficial theory that the minors can enforce the contract, and these are something that the law recognizes as well. Moving forward, friends, looking at the other type of mental incapacity, that is of the unsound person. Now, soundness of mind is very relevant, friends, because these are commercial transactions. These are transactions in which you have a duty to perform, you have a duty to pay. See, do you expect someone, to give a loan to an unsound man and then try and recover that loan amount? So, soundness and unsoundness of mind is a very critical aspect to contract. Now, there is hardly any test that we think for soundness. Okay, but there are legislations that can guide you. For example, we had the Lunacy Act quite early on. Today, we have the mental health care legislation, which does talk about the mental soundness and unsoundness. What can be categorized as a mental problem or a mental challenge, and when is a person considered to be normal? Right? There are legislations that can guide us, but the unsoundness of the person under traditional contract law very clearly meant that he was suffering from a mental ailment that is affecting his mind, the decision-making mind, the rational mind, the mind that can make the choice between right and wrong. So when a person sells a property which is worth 20,000 just for 1,000, right? Can you say he was unsound mind? Not necessarily. So it's not necessarily that a cheap sale or a discounted sale will test unsoundness. But if there are additional medical factors, evidence of the sort that he was born with mental issues, and those were challenges, right? These could be, say, an attack of epilepsy. It could be an attack of depression. It could be an attack where it requires mental health care. It could be psychiatric. It could be psychological. In those circumstances, I think you will notice that at the time when the person is under a mental health condition, those times we say they are lucid intervals, where you have soundness at times and unsoundness at times. In those circumstances of unsoundness, obviously you should not have the capacity to contract, right? You can have capacity to contract once you have recovered, and hence, yeah, a sale is okay, a purchase is okay. I think those are, parameters, right? So the law very clearly excludes persons who are unsound. They do not have the right to make a contract. So anyone else is not also encouraged. The contracts will not have any recognition in the eyes of law. Similarly, drunkards or people who are intoxicated. So drunkards, I've just said, those people who drink. When they are drunk, probably you don't see any kind of rationality. They do not have the right mind, and that is not a time when they should have the capacity to contract. So if you're intoxicated, friends, obviously you should be not having the capacity to contract, right? So those things are, I think, very, very relevant at this point of time for us to understand. And please note, this kind of drunkenness or intoxication also is extended to people who may be under a substance abuse, who have taken drugs that actually give them a high. But please note, at that point of time, they are in no position to understand what is happening around them, right? So we usually exclude them, but the point here is, each of these, friends, say unsoundness or intoxication, the law is not going to come to you unless you have clean hands, right? You cannot incapacitate yourself and then claim the benefit of law. This kind of incapacity should be not due to your fault, right? If you have contributed to that fault, then please don't expect the law to come to your rescue or protect your interest and hold the contract to be involved, right? So voluntary drinking is no ground to hold a contract as void, right? You drink and then you make a contract, the law is not going to come to your rescue. The law is not going to protect your interest, right? Suppose it is induced, it is cheated drinking or something like that in terms of intoxication or any other thing, then yeah, the law will say, okay, at that point, you were incapacitated, you did not contribute to that incapacity, and hence probably we can come to the rescue. So I think those will be something the courts will definitely try and see and judge before they decide when to intervene in contracts and when not to intervene in contracts. Moving forward in understanding physical incapacity to contract, I think one will have to appreciate here that while mental incapacity and physical incapacity are both important to judge who can actually enter into a valid enforceable contract, one cannot forget the fact that we have visually impaired persons in society who probably cannot see and read contractual documents. While they are not prohibited from making oral promises, there are certain constraints that they face while they enter into contract, and hence, not the fact that for example, they may put signatures, they may put their fingerprints, or any other mechanism. But there is a kind of not so full capacity in certain individuals in our society, either because of some kind of specialty challenge that they face, and hence some of these contracts that are with visually impaired persons or with persons of old age. Now, old age, friends, will result in the kind of slowing of the mind, the kind of understanding of commercial situations, the capacity to read properly. You may need spectacles. Sometimes there is an age challenge in So I think all of these infirmities may come to an individual, and this will pose physical challenges to an individual. And in those circumstances, I think there is a presumption that these kinds of contracts may not be fully enforceable if one of the parties can prove that the contract has some mischief or some kind of influence that actually resulted in these contracts to be set aside. So there can be capacity challenges due to age, due to physical issues, and I think the courts must take that into consideration while contracts are being enforced as well. So these can be grounds to hold contracts as being not enforceable. So one will have to completely understand that as well. Moving forward, if you look at legal capacity, friends, or legal incapacity, this is important because so far in this chapter, we were talking about capacity in terms of a natural person. That is me and you. Now we know persons in the eyes of law are two kinds, natural person and juristic persons. What is a juristic person? It's a company. It could be a university. It could be an association of individuals like a partnership or so on and so forth. So a cooperative society, a trust, all of these we consider as person in the eye of law, and we call them legal or juristic persons. Now interestingly, when it comes to juristic person, who can make a contract, right? The company cannot make a contract on itself. It requires some representative to make that contract on behalf of the company, right? This is one aspect about capacity. Naturally, only do you expect a company to be represented by a minor? No, you expect a company to be represented by an adult and also of sound mind, right? Having said this, friends, we will probably talk about this person who represents the company under what we call as the chapter on agency, right? Because you are an agent when you represent the company, you are an agent when you represent the university, you are an agent when you represent the government while making this contract. So the capacity of the agent and the authority of the agent is a separate topic altogether. However, now let's talk about the company itself and the capacity of the company to make a contract. Now you know that when a legal person is created, right, you need to incorporate the legal person. You have to bring him into existence in the eyes of law. For example, a university has to be established through a statute, or it has to be registered. Once registration happens, the legal personality commences. A company has to be incorporated before the legal personality can come into existence. So we call incorporation registration as an important step for the legal personality status to come into existence. Having said this, you will again come to this point that there has to be certain documents to incorporate. For example, in a company, we say there are two important documents that go to the process of incorporation. Once these documents are incorporated, the company comes into existence.